What happened? There's Mr. Flanagan. Who's representing Mr. Tomlin? You or Mr.
Sorry. Not sure I like it.
All right. This is here for a possible plea.
Hang on, Judge. Can we second?
That's my question.
Little background if this is your first time watching this case. The defendant originally appeared in court dressed as Spider-Man while facing serious criminal charges. He first entered a guilty plea, later withdrew it, and the case was scheduled for trial. But when the trial date arrived, he failed to appear in court. The judge issued a bench warrant for his arrest. He was eventually taken into custody, and that's how we arrived at today's hearing.
All right, I've been handed a document indicating Mr. Tomlin is going to enter a actual plea of guilty. Is that correct?
Yes, Judge.
Yes, sir.
In 2022 CR 319, he would be entering a plea of guilty to count 1, aggravated statutory rape, Class D felony, and receive a sentence of 2 years to serve in Tennessee Department of Corrections as a range 1 offender. That will be consecutive to counts 3 and 4. He'll be required to be on the sex offender registry. Count 2, it would be a sentence of 2 years to serve, aggravated statutory rape, to serve in the Department of Corrections as a 30% release eligibility. That will be concurrent to count 1, sex offender registry. Count 3 is sexual exploitation of a minor. He would receive a sentence of 3 years to serve in Tennessee Department of Corrections as a release eligibility of 85%, and he would be on the sex offender registry. Count 4, sexual exploitation of a minor. He would receive a sentence of 3 years to serve in Tennessee Department of Corrections. That would be concurrent with count 3. He would be ordered to pay the court costs. This plea would be final with no withdrawal or appeal. Mr. Tomlin, raise your right hand and let's place you under oath.
Yes, ma'am.
State your full name for the record.
My name is Troy Allen Tomlin, Jr.
Mr. Tomlin, you and I have some history. You've appeared before me on a number of cases. I want to make sure that we understand each other. You appeared before me, for example, on one time wearing a Spider-Man outfit underneath your clothes because you were headed to Comic-Con in Nashville, and I did not allow you to go because you were facing these type of sexual charges involving minors.
Yes, sir. And I apologize for that, sir.
That's all right. I just wanted to make sure that you understood that I remember your case well. And you entered a plea previously in this case, and then later came back in and wanted to withdraw your plea. You understand that?
Yes, sir.
You understand that this go round, you've got not 1 but 2 of our finest criminal law attorneys who are representing you, one on either side of you, supporting you, defending you, and giving you advice, and that they've worked out this plea, and this is going to be a final plea. Do you understand that?
Sir.
You're waiving your right to appeal, and that this court will not consider any motion to withdraw your plea after today. Do you understand that?
Yes, sir.
Well, I might have to consider it, but I'm not likely to grant it. If you're raising your hand, that's not a good thing.
I was just trying to tell you that I'm just tired of losing and I want to do better.
All right. Well, this is to give you an opportunity to do that. So do you understand everything you're charged with? Do you understand what the range of punishment is you're facing? Have you and your 2 lawyers been able to discuss this case fully with you, and y'all discuss what the range of punishment is and any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty. Do you understand you have a right to plead not? Did you turn that microphone off? Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of any crimes.
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You You understand that if you went to trial, you'd be presumed to be innocent. You would not have to testify or prove anything. No inference of guilt would arise because you did not testify in your own trial.
Sure.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed 2 appeals and have a lawyer appointed to help you with this appeal.
Sir.
You understand that you went to trial. I'm sorry, by entering this plea, you're waiving your right to a trial and to an appeal, and I will be simply approving what you and your lawyers have agreed upon with the state
Yes,
as
sir.
a disposition. You understand that?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you understand this is going to result in there's 4 different felony convictions, and those convictions are going to all be on your record in the future to make more severe the punishment to receive if you're ever again convicted of a crime. You understand that? You understand that's going to require you to be on the sex offender registry, and that means the sex offender registry has certain conditions that are going to have to be met that are in addition to regular probation. Do you understand that?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a hearing according to trial according to this by entering this plea of guilty according to this agreement?
Yes, sir.
Do you understand if you plead guilty, the court of the state may ask you questions about these offenses, and if you answer these questions under oath on the record in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we find that you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your
No,
will?
sir.
You understand that I cannot accept your plea unless I'm satisfied that there are facts to support it and that you are in fact guilty of these charges.
Yes, sir.
Now, I'm going to ask this question of the lawyers. Is this a best interest plea where the state is required to provide me with a factual basis?
Yes, sir. He's got some limitations, as the court knows.
Well, we've already had an evaluation
Yes.
performed under a court order
Yes.
evaluation. He was found to be competent to stand trial and found that there was no defense of insanity available to him
Correct.
under that evaluation.
Just
so-
don't think he could articulate answers ready to ask him, and I would ask the state to lay down.
All right. Let's let the state, do you have the opportunity to lay a foundation for me factually?
This case will proceed to trial. The proof would show that in March of 2022, Mr. Tomlin had sexual intercourse on 2 different occasions with a victim that I'll refer to as JB. JB was 14 years old at the time. A subsequent interview with police, Miranda, Mr. Tomlin admitted to having sex with JB on 2 different occasions. A phone dump was done of Mr. Tomlin's phone in which a photo of JB's breast was located, which would constitute child pornography under TCA code, and a video of JB dancing nude in the shower.
All right.
This happened in Dixon County.
Thank you. Mr. Tomlin, do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
All right. You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services? You've had not 1 but 2 lawyers representing you now. You believe that they've done a good job representing you?
Yes, sir. They did an excellent job.
All right. Mr. Flanagan and Mr. Wennick, do either of you know of any reason he should not enter this plea? Anything further from the state? So this disposition is at the victim's request. All right, so that the record reflects the victim in this case has requested this disposition of the case. All right, then Troy A. Tomlin in docket number 22 CR 319, upon your plea of guilty to count 1, aggravated statutory rape, I find you guilty, sentence you to 2 years to serve in the Tennessee Department of Corrections as a release as a range 1 offender. Count you're ordered to attempt to enroll and comply with the sex offender registry. Count 2, you're found guilty of aggravated statutory rape, sentenced to 2 years in Tennessee Department of Corrections. That will also be served concurrent to count 1, and that will be on the sex offender registry as well. Count 3, sexual exploitation of a minor. That will be sentenced to 3 years to serve at the Tennessee Department of Corrections as 85% release eligibility, and you will be required to be on the sex offender registry. Counts 1 and 2 will be served consecutively to this one for an effective 5-year sentence to serve. Count 4 is sexual exploitation of a minor. He's sentenced to 3 years to serve at the Tennessee Department of Corrections, release eligibility of 85%. That will be served concurrent with count 3, Again, he will be required to attend the sex offender registry. He'll be ordered to pay the court costs. This plea is considered to be a final plea. All appeals are waived, and there will be no consideration of a withdrawal of this plea.
Judge, we will submit an agreed order with the jail credits. There was some.
That's fine. Jail credits will be submitted by an agreed order.
The case ultimately concluded with the defendant receiving a 5-year prison sentence, mandatory registration as a sex offender, and a final plea agreement that permanently waived his right to appeal or withdraw the guilty plea. With that ruling, a lengthy legal battle finally came to an official close.